The Essential Directorship Masterclass, Achieving Excellence at Board Level. What is a company? A company is a corporation created by a legal process as a legal entity separate from the human beings associated with it. In effect, it becomes a person in its own right. The legal capacity to act as a person, distinct from the persons who hold the capital, offers the opportunity to such persons to limit their liability for the company's debts to the amount they have agreed in advance to make available to it. It's the liability of a shareholder for the company's debts that is limited. So it's quite important to understand that. The reason for setting up a limited company is to limit the risk taken by the shareholders, not to protect the directors. There is no such liability to the damages for which a director may be held liable as a director at the instance of the company or of a third party. So I repeat, directors are not protected by limited liability. Becoming a limited company enables capital to be raised whilst limiting the financial exposure of the shareholders. It provides for simple transferability of ownership through the buying and selling of shares. It gives continuity to the business beyond the life of the original founders. So it has been a really successful model since introduced some 100 or more years ago. So let's just consider some of the types of company you might be associated with. The public limited company and the private limited company. The difference is that a private limited company is restricted in most cases to no more than 50 shareholding owners, and a public limited company has to have a qualified company secretary and various other attributes. You might be involved in the subsidiary or a group company. These are likely to be private limited companies, probably within a public limited company situation. Or you might be in a family business. You might be in a company limited by guarantee, or a community interest company, or a company formed by statute or government charter. So these last three are likely to be outside the normal commercial operating world, and they've been set up for particular reasons. A public company, PLC, is one that is registered and describes itself as such. In the UK, only a PLC may invite members of the public to subscribe for its shares. A private company may not offer its shares to the general public. Usually, the number of share owners is restricted to a relatively small group of people closely connected with the company. A company limited by guarantee has no shares. Members who act as guarantors commit to making a nominal contribution in the event of winding up. Community interest companies are social enterprises that are allowed to reinvest their profits in the purpose of the business or into the community. So let's look at the charter. The Memorandum of Association. This is what is required for the setting up of the company. The wording can't be changed later. And since 1989, there has been a general commercial company status, which basically means you can set yourself up to do anything that you want. Charities and community interest companies will have their own style of Memorandum of Association. The important thing for you is the Articles of Association, because these are the rules for running the company. They explain how you run the company. The articles set out the rules for running the company. It's important, therefore, that directors should study the articles of the company. The articles can be amended by a resolution formally approved by a meeting of the company's members. Now, the Articles of Association are likely to include the following: the company name, the proposed location of the company's registered office, the object of the company, the statement regarding liability of its members, detail of the company's share capital, name of each individual shareholder, rules for the company's internal regulation and management, meeting procedures, powers of directors, members' rights, and procedure for paying dividends. So these are quite detailed things, and if you wish to change them, then you must make the changes necessary to the articles. So let's just stop for a moment and consider who's who in a company itself. There are 4 basic categories of people, and you could be 1, 2, 3, or 4 of those categories. And it's important for you, if you're in more than one category, to make sure that you recognise conceptually which hat you're wearing at a particular time. So, as it says here, you could be a director, or you could be a shareholder, you could be a manager, you could be a stakeholder, 1, 2, 3, or 4, independently or together. So let's just think, who are the stakeholders? So the stakeholders include the shareholders, they include the directors, because the directors have some interest in the business itself. Certainly, stakeholders include creditors, and they include the employees. They include the customers, they include debtors, government organisations, and the community. So what's a director? According to the Cambridge Business English Dictionary, a company director is one of the group of managers at the highest level in a company who control it and are in charge of making decisions about how it's run. That's an interesting definition for me, because it gives no recognition of the legal status or responsibilities of the directors. So let's see what the businessdictionary.com says. A company director is an appointed or elected member of the board of directors of a company who, with other directors, has the responsibility for determining and implementing the company's policy. Directors hold a position of trust on behalf of the shareholders and direct the company's operations on their behalf. The extent of the director's authority depends on the company's Articles of Association. So, reminder there, the Articles of Association are actually quite important, and you should take the trouble to study and understand them. The Board of Directors' key purpose is to ensure the company's prosperity by collectively directing the company's affairs, whilst meeting the appropriate interests of its shareholders and stakeholders. In addition to business and financial issues, boards of directors must deal with challenges and issues relating to corporate governance, corporate social responsibility, and corporate ethics. The board of directors is appointed to act on behalf of the shareholders to run the day-to-day affairs of the business. The board are directly accountable to the shareholders, and this would normally be at a general meeting, the annual general meeting or a special general meeting. So let's consider the functions of the board. Firstly, stewardship. Secondly, fiduciary duty. And thirdly, compliance. And strategy. So the first 3 are very important, but unless they work on the strategy, their first 3 become somewhat irrelevant. Now here's a quote from a Minister of Trade and Investment in Nigeria, which I thought was rather nice. There is a difference between managing a company or corporation and the board. The board determines in many ways the values and culture of an entity and plays a big role in terms of improving the competitiveness, profitability and productivity of those entities. In other words, strategy is important. In addition to business and financial issues, boards of directors must deal with challenges and issues relating to corporate governance, corporate social responsibility, and corporate ethics. Oversight. Directors must ensure that appropriate processes and controls are in place to manage and monitor risks and to provide the smooth, effective, and efficient functioning of the business. Insight. Directors are there to add their experiences and wisdom, not to second-guess management, but to supplement and enhance executive decision-making. Foresight. The directors are there to provide a perspective on the future that helps management identify those opportunities that are most worth pursuing. Fiduciary duty. Directors owe a fiduciary duty to the company. I'm sure you've heard that many times, but what does it mean? This means that they must show it the highest loyalty and act in good faith in its interest. And they're talking about here loyalty and interest of the company. The directors must act honestly and diligently. Decisions must be within the company's objects, coming back to Articles of Association, and be in the interest of the company and not for any collateral purpose, nor for a personal motive. And this applies to limited companies owned by small numbers or even individual people. Your responsibility is to the company. In addition to the business and financial issues, boards of directors must deal with challenges and issues relating to corporate governance, corporate social responsibility, corporate ethics. It's the duty of the directors to ensure that proper and accessible accounting records are kept, to prepare and approve annual accounts, to ensure that copies are then sent to the parties entitled, to lay the accounts before members, that's shareholders, in general meeting, to deliver accounts to the registrar of companies. Auditors must be appointed at each general meeting before which accounts are laid, to act until the next such meeting, when they can either be reappointed or replaced. So, time for coffee and the memorandum and articles. So, obtain a copy of a company's memorandum and articles. Very important. Read them carefully and make notes of anything that you will need to refer back to in the future. And if you can, obtain your own copy and highlight the key sections and then file it in your director folder. So let's move on to the next video.